Welcome to the Mitigating Unauthorized Scraping Alliance, or MUSA's webinar today. The web address for MUSA is antiscrapingalliance.org. The aim of MUSA is to bring together leading companies to protect data from unauthorized scraping and misuse by identifying and promoting best practices to prevent unauthorized data scraping, educating the public on the harms of such scraping, and providing insight, knowledge, and expertise to policymakers around unauthorized scraping. Today, I'll interview Professor Timothy Edgar about his white paper, Talking Past Each Other, the Legal and Technical Challenges of Harmful Web Scraping. Professor Edgar currently serves as the Professor of the Practice of Computer Science at Brown University and is a Senior Fellow at the Watson Institute for International and Public Affairs, as well as a lecturer on law at Harvard Law School. Before this, from 2001 to 2013, he worked at the ACLU, the intelligence community, and the White House, working to make a difference inside America's intelligence agencies. He is the author of Beyond Snowden, Privacy, Mass Surveillance, and the Struggle to Avoid the NSA, and winner of the 2018 Chicago-Kent College of Law Rory C. Palmer Civil Liberties Prize, and is a contributing editor to Lawfare. Professor Edgar, thank you and welcome to this webinar.
Great to be here, David.
First, the title of your paper, what is web scraping?
Sure. So web scraping is a common tool that computer scientists have used, technical people have used really since the beginning of the web. And what it does is it gathers information from websites. Usually involves three steps. First, the software will send an HTTP GET request to the website. It's the same process you use for browsing the website. And it looks for a pattern that it's been programmed to collect. And then it converts that data to some kind of usable format, sometimes like a spreadsheet or something like that. Often you use a headless browser for this tactic. That means that instead of rendering the web page the way you and I would do, it's just gathering the data directly. And so it's a lot faster and more efficient, and it's done in an automated way.
And what is the difference between web scraping and, I've heard in the past something called web crawling. And I guess that's, what are the two? Because they sound very similar.
Well, web scraping is more invasive. Web scraping is actually getting the data from the website and downloading it. Web crawling is just identifying the data, finding out what's out there, what websites are there. Obviously, they have to get a little bit of data to figure out what they're looking at. But they're related to each other. The crawlers and scrapers work together to help us with things like organizing the web, search. Lots of different functions of the web, use these two particular kinds of techniques in order to try to make sense of this vast quantity of information.
And I guess for web crawling, is that more about indexing or like for search or, just to further contrast versus web scraping? Like how?
Yeah, exactly. Web crawling is really about indexing and about search, telling me where particular information or websites are located, rather than trying to ingest all this large quantities of data that are on those websites.
And from my computer science days, I remember something called a robots.txt file, and you could set that up so that your site wouldn't be crawled. Are those still used today, or can you tell the audience a little bit more about the robots.txt file?
Yeah, so it's a simple file. It's available at robots.txt. It's what I would consider a norm of the web, where it instructs robots either stay away from this site. I don't want this site available in general to crawlers, or here are parts of the site I don't want you to crawl. Other parts are fine. I want you to look at my homepage or some other areas, but here are areas I don't want you going that deep. And it's really just a request. And it's interesting because you mentioned in your computer science days, you kind of learned about that. As I discussed later in the paper, some of these norms are starting to break down. And you see a lot more scrapers and crawlers ignoring those requests today than you would have, a while ago.
So you use the term in your white paper, unwanted web scraping. So how do you define that term?
Sure. I define that by terms of service. So, I talk further in the paper, if an activity on the web is unauthorized, typically that means it violates the Computer Fraud and Abuse Act. At least that's the way I think of it. So I think of that as very much a technical legal conclusion that, this activity violates the CFAA. And whether web scraping that simply violates the terms of service violates the CFAA is really a hotly debated issue. Probably not, based on the Supreme Court's decision in Van Buren versus United States of a couple of years ago, or maybe it was just last year, I forget. So I wanted a term that would say, look, if a website doesn't want its information to be crawled, it might indicate that in terms of service. It might indicate that in terms of a cease and desist letter or robots.txt. That's unwanted web scraping, right? It might be unauthorized. It might not be unauthorized under the CFAA. And also it might be harmful or it might not be harmful, but it's definitely unwanted. So I wanted to kind of have a word to describe what unwanted web scraping was.
You also discuss innocuous web scraping. What's the difference between unwanted and innocuous web scraping?
Well, innocuous, I guess I don't know if I was doing that technically, but plenty of websites are perfectly happy to have parts of their website scraped. That's pretty innocuous, as long as they're not violating any other rules or the privacy of their of their users. And there can be beneficial uses of this tool in order to for example, for scientific research and other things. If it's done in an ethical manner, then I would think that's pretty innocuous, maybe even beneficial to society.
So, but in general, how is web scraping harmful, based on what you were saying in your paper?
Sure. So I think there's a real common theme with most of the harmful uses of web scraping, and that is the automated collection of large amounts, bulk collection, as we used to say in the intelligence community, of people's personal information in order to then exploit that personal information for some kind of generally commercial purpose or even criminal purpose. That could be very harmful types of web scraping. If you have your information collected and used and even posted on the public areas of a social media site, for example, you expect that information to be used in a particular context. That's one of the ways we think about ethics and privacy. And so if that information is then taken by someone and used in a completely different context, especially one that's unanticipated, that's surprising to you, then to me, that's a very harmful potential use of web scraping. And I give some examples in the paper.
And so now the topic du jour in every media is generative AI. And how has generative AI increased the demand for scraped data?
Sure. So generative AI, AI models are based on statistics. They're based on trying to predict what a particular, image or, text would look like based on what other things that are similar look like. We're all familiar with all the stories about ChatGPT, where you give this tool a text prompt saying, write me an essay about Abraham Lincoln, and boom, you've got 4 paragraphs about Abraham Lincoln, right? And instead of a search engine, which might, point you to something a human has written, like a Wikipedia article, it's just generating, a new essay. But it's not really new. It's trained on enormous quantities of data, and it says, this is kind of what this looks like based on the probabilities of the data set I've been trained on. So now you can see why that creates enormous demand for data sets. If you're trying to create realistic, synthetic text with a large language model, what you need is massive quantities of actual real text. The more recent, the better. The more natural, the better. And so social media sites or chat sites or all sorts of different kinds of sites could be sources of that information.
And do you have any sense of how large some of these training sets are that are used? Are we talking about megabytes, something that can fit on a CD? I mean, what is how much data are we talking about that's used to train some of these models?
Um, Very large. Certainly many more than you would put on a CD. I don't have that at the tips of my fingers, but it's definitely the larger the better in terms of the accuracy of the model.
That's right. And in your paper, you mentioned that the norms, and you kind of started with this, the norms in the technical community have broken down. And I guess what were some of those norms? Are we talking about honoring the robots.txt file, or how the automated tools that are used to scrape and pull down this data operate? What are the norms that are no longer being honored?
Sure. Well, I think that certainly robots.txt is a good example of a technical norm. Also, just general common sense of, here's a data set that looks useful that I might be able to use. But if this was, for example, a dating site, maybe this is sensitive. Maybe I should be scraping something else, that doesn't have that kind of personal information. But then also the terms of service that website owners use to describe what you're allowed to do on their site. Whatever the legal status of those, and we'll get into those, I think, in a minute as to how enforceable they are. They certainly indicate what a website owner wants done with their site. And if you're not going to honor the terms of service, even if that's not a legal violation, and it might be, it's something you'd want to think about pretty carefully. You'd want to say, I have to have a pretty good reason not to do this. And I think those norms are breaking down. AI is a big example of that. It's unleashed so much scraping behavior, for example, that it's flooded certain, websites with these kind of requests in a way that creates even management problems. And the commercial pressures of, trying to come out with a commercially viable or usable product that's going to get buzz in the marketplace, it's going to be hard for someone coming out of a computer science program, or a young programmer who's told, write me some stuff to scrape all this data so we can get our AI tool out, to say, well, I think that we shouldn't be scraping this site or that site because of this or that, feeling that it's wrong or that it's not wanted. So I think that's part of what's causing these norms to really break down.
And you mentioned something interesting, and I think a lot of, just to make sure our audience is on the same page, what is the difference between a terms of service, or TOS, and the privacy policy, and where should the computer science student you're referring to look to see if there's any objections to scraping or this type of activity?
Sure. I mean, I think that terms of service would be the first place to look. Privacy policy, as I understand it, usually describes what the company itself does with data, right? So if I'm running a website and I'm collecting data on my users, I'm going to have a privacy policy that says, here's the data I collect, here's what I do with it, and so forth. And those are enforceable promises. If I'm violating my privacy policy, I could get in big trouble with the FTC. I might get sued if there's some kind of harm that's resulting from that by individuals. But it doesn't apply to a scraper, right? A scraper didn't make those promises. But the terms of service does apply to any user of that site. A user that's, become a member of the site, or just, visits that site, depending on, how the terms of service works, is going to be generally, that's going to define that relationship. And so I think you'd look at the terms of service. You might want to also, have some, familiarity with the privacy policy, just because, these aren't hard and fast terms. And, depending on how sophisticated a website is, they may put, language in one or another place. But I would be, I would be happy if any student was going to look at any of these things, actually, and pay attention to them. But that's definitely, I think that's the difference between those two things in general.
So I guess in your paper, you refer to the Clearview AI case as the most famous example of aggressive and privacy invasive web scraping. Could you tell our audience a little more about this case and why it was privacy invasive?
Sure. So Clearview AI is a big company that has scraped billions of photographs, little billions with a B, photographs from the web, and they're open about it. They talk about that they have 30 plus billion images from public web sources, including news media and mugshots, public social media. And then they match that with a facial recognition algorithm. And then they sell it to governments and private companies. This is a surveillance tool, essentially. It's a tool that they're marketing to the US and other governments around the world, as well as private companies, to be able to identify people in investigations. Now, my sense is that it would be one thing to say, okay, you need to balance public security and safety with privacy, but this company really has been pretty aggressive. It's violated legal obligations in Europe and the United States, the GDPR, as well as the Illinois Biometric Privacy Act. I just think it's an example of probably the biggest impact on privacy that we've seen so far of web scraping. The idea that you could be walking down the street and somebody could, without your knowledge, take your photograph and then upload it to this tool and match it not only to something that you've uploaded, maybe on your Facebook page or on your other social media, but somebody else might have uploaded and tagged you. And then this would be able to match your identity.
And so you mentioned that this company was absolutely using scraping, or certainly using scraping, to gather this information and pull it down from various websites and get these images and put them into their system or train their AI to identify users. I guess the next question would be, what about other sites that have images? For example, like dating websites. Have we seen any scraping activity and any abuses in that area? And what are the risks there? Because I think people generally put a lot more information in dating profiles than they would perhaps in a regular, say, LinkedIn profile.
Sure, yeah. Dating websites have been scraped. They've been scraped both by researchers who are trying to engage in various types of social science research, as well as by more malicious actors. One thing that I have in the paper was a particular example, which is where a researcher who was looking into this phenomenon, not doing the scraping, went on the gray market and was trying to find out, I wonder if I can buy information on dating profiles. And for $153, was able to buy 1 million dating profiles that had been scraped. So that really gives you some pause. I mean, just going online and for a relatively small amount of money, being able to purchase that kind of intimate data. And of course, when you participate in online dating, you are putting your information and your data out there to some degree. You're having to reveal some personal habits, even sexual habits and preferences. Most people, once they've found a partner, if they're in a longer term relationship, will delete a dating profile and will hope, they know that there's some chance that information could come back, but the scraping really increases the risks of that data being hung on to and being used for purposes that obviously people didn't intend it to be used for.
And you touched on the use of scraped data by malicious actors. Can you talk a little bit more about that? Because I imagine first name, last name, email address, all the kinds of things that you would get from any of these sites would be be used by hackers to compromise individuals. Is that correct?
That's exactly right. I mean, it's the first step in a lot of hacks, in a lot of scams and other kinds of malicious activities to gather information. And one of the most sort of maybe obvious examples of that is scraping data for email addresses and phone numbers, which companies often put on their websites. Some companies are taking steps to try to, make that information harder to access, at least by scrapers. And once you have that information, of course, you can now send spam, you can now do robocalls and all that kind of stuff. So that's just one example. But all this reconnaissance is helpful in terms of phishing, in terms of understanding the nature of a company's site, to try to hack into more private areas of the site. And scraping is just, basically the bread and butter tool of this reconnaissance step in malicious activity.
Now getting back to artificial intelligence and generative AI, and we talked a little bit about the size of the terabytes of data that's kind of used to train some of these AI models. And I guess another concern is that some of this scraped data may contain, and we just talked about this, but private information or personal information. And based on your research, are these researchers or people, are they making any efforts to try to remove the personal data, or what are the risks of just a person's private information or personal information winding up in one of these large data sets that are used to train AI or used by AI researchers?
Sure. The answer is very spotty. We're at the early stages of this, even in academic environments. I think that a lot of institutional review boards are very inconsistent in how they apply their ethical guidelines. In the commercial space, I think there's an enormous amount of commercial pressure. Ethically, AI tools that are being created should try to take steps to strip out personal information or to limit the potential for exposure, but it's by no means foolproof. And the way that it would work is something like this. I mean, if you ask for information to be generated on a very specific topic, let's say, it may be that there's a relatively small number of data sets that meet those very specific parameters. And as it generates what it thinks is new AI generated artificial images or text, it may be so similar to the data that it's been trained on that it's basically revealing that private information. Those private chats that it was trained on are now kind of being massaged and generated as output for the AI algorithm. That's not really how it's supposed to work. Obviously, it's supposed to be generating something new, something synthetic, something that isn't just the same as what it's been producing. But there are many situations in which this is a potential for leakage of that personal information from the output of that AI generated tool. And of course, the other big impact on privacy is just the demand for that data. So those are really two different potential harmful impacts that both involve the scraping of data in order to feed it to AI tools.
So I guess another question is to set the foundation to talking about some of the case law in this area. You talk in your paper about the CIA triad as a central goal of cybersecurity, and that is authentication, authorization, and access control. Can you talk a little bit more about the CIA triad and why it's relevant to some of the case law in this area?
Sure. So CIA triad is confidentiality, integrity, and availability, and those three things are kind of the things you're trying to achieve with cybersecurity. So you want data to be confidential, you want it to be, what it says it is, and you have integrity, you want it to be available. I talk about the three A's, another sort of three letters: authentication, authorization, access control. These are techniques or functions really that help us achieve the goals of cybersecurity. And there's some common misconceptions about them. But basically, authentication is identifying, who or what or the characteristics of what's trying to gain access to information or resources in a computer system. Authorization is the decision to grant that access. And then access control is basically the limits on that authorization decision and those access decisions. So, there isn't one exact definition of these three concepts, but they're very well understood, technical concepts at a somewhat high level in the field of cybersecurity. There's all sorts of different specific technical techniques to try to achieve those, but those are the goals that you're trying to achieve. You're trying to authenticate, you're trying to authorize, you're trying to control access.
And in your paper, you also talk about some misunderstandings, and there's three of them, and just want to run through them for the benefit of the audience here. So we have common misunderstanding. Number one, authentication and authorization are basically the same thing. And why is that not true? Why is that a misunderstanding?
So they're not, the technical literature is very clear that these are different concepts, but they're often going together, and that's why people get confused. Let's take a fairly common scenario of logging into a website. When I log into a website, I have to authenticate myself to that site. Oftentimes I'll use a username and password combination to do that. So now I know that you at least know the username and the password associated with that username, so you have an account with us. Now, after I've done that authentication step, and maybe I have other things, I have two-factor authentication or other things that go into that authentication step. The next step is now I'm authorizing you access into this, this account. So those are two distinct functions. They're happening pretty much at the same time. I authenticate and then I'm authorized, but they're distinct processes. And it's important to keep them distinct because, as we'll get to in a minute, the concept of authorization is also a legal concept in the CFAA, but it's technically distinct as well, because you could be authenticated without being authorized. You can be authorized without or before you've even been authenticated, but commonly you're authenticated first and then authorized.
So this goes to the second common misunderstanding. Authentication and authorization are synonymous with a login process that allows a computer to limit access to a particular user with an account. So I think
right. And so I gave you the most sort of common, familiar scenario. And the problem is that a lot of people, especially people who are not, technical cybersecurity types, will just think, well, that's the only scenario, and it's absolutely not. Really any process that is trying to identify not just a user, but it could be a device, it could be a piece of software, it could be really anything, is an authentication process. It could even be a process to determine that somebody is not part of a class of people. That's also an authentication process. They could use passkeys, for example, which operate in the background. There's no login. You don't see any logging going on. It could be measuring signals from a device and saying, okay, this device has this IP address. It's running this kind of software. It has these characteristics. It meets my criteria for what I've chosen to allow into my resource. That's an authentication process, but you have no idea who is actually behind that device. So sometimes we think of authentication and we just immediately our mind goes to the most common or the most highly visible one, and that's logins and passwords. But that's not what that term actually means. And in fact, we're moving away from that. There are lots of problems with logins and passwords. Passwords themselves are a real vulnerability. And so it's not going to, in a relatively short amount of time, most authentication will probably not be using this particular process.
And then for the third misunderstanding that you talked about during your paper, authentication must invariably come before authorization. Can you talk to that a little bit?
Yes. So these are two steps, and obviously they kind of go together most of the time. Authentication saying, I'm identifying a user or a device or a set of characteristics. Authorization is a decision to grant access. And essentially, we're used to thinking of them as occurring in that order, but they don't necessarily have to. A good example of where they don't is if you are trying to get into your account and you exceed the authorized number of password guesses, right? It'll lock you out. That's essentially a decision to deny authorization to a user that has not yet been authenticated. And in fact, the whole point of that authorization denial is to protect the authentication process. So, the question of whether to grant access to a resource is the authorization decision. The question of measuring who or what device or what the characteristics of the device are is an authentication decision. And obviously they're related, but they're distinct processes.
And now with that important foundation, and I'm sure some people will have to play that part over again to fully digest, the differences between authentication and authorization. How have courts struggled with these different concepts, and how has that caused some problems for companies dealing with trying to protect their assets against unauthorized scraping?
Sure. So the main federal anti-hacking statute is called the Computer Fraud and Abuse Act. It's very old. It stems from the mid-1980s, and it uses the terms without authorization and exceeding authorized access. So it really has two of those three A's. It has authorization. It has access. It does not have authentication as part of that triad, and that's been a problem because courts have struggled with understanding what do they mean by authorization or authorized access. And basically two main schools of thought developed over a couple of decades. One was this is purely a legal concept. Another was this is really a trespass statute. We'll talk about that in a minute. But in the Supreme Court, in its decision in Van Buren versus United States, basically gave us a great answer to that question and said, actually, authorization and access and all these terms are computer science terms. And you should use them in a computer science way to refer to a decision, a gate that authorizes your access to a particular file or a particular part of a computer. That's the way this term should be read. And that was kind of a eureka moment for us. But it still kind of left a little bit unclear what was the role of authentication in this process, since that doesn't appear in the law anywhere. And as we'll see, even with what we seems to be a pretty clear answer from the Supreme Court, some courts still seem to be a little confused about exactly what authorization and authorized access mean, even after the Van Buren decision.
So, looking back at the history, is there any reason why the law was drafted in that way? I think in your paper you mentioned, some of the original systems or the early systems were air. And is there any?
Yeah, this was written in the 80s. There's a great story about, President Ronald Reagan, who liked to watch the latest Hollywood movies with his background in Hollywood, seeing a movie with Matthew Broderick called War Games about a teenage hacker who hacks into NORAD and creates almost a nuclear war. And that actually did happen, and it was part of the debate over the CFAA. There wasn't really a World Wide Web. There wasn't an internet. And so when they drafted this, they just didn't think about authentication. They didn't think about systems that were open over the internet. They thought about systems that were closed to only authenticated users.
And so I guess would the logical next step be that this law needs to be kind of updated or amended to
I propose in the paper that I think the best answer to addressing some of the problems with unauthorized scraping is just an update of the CFAA that addresses some of these missing definitions, that clarifies the role of authentication, that clarifies the meaning of authorized access and authorization, so that it's clear that when I am trying to defend my website against this kind of malicious behavior, and I'm employing techniques and tactics that are basically designed to deny authorization in the technical sense, to deny authorization to a scraping machine, that I have the right to do that. And that if you try to defeat that, that is a form of hacking. If you're doing it for malicious purposes, so I think that would be one way to address this problem.
As a privacy lawyer, I'd be remiss if I didn't ask you, how does the GDPR, various privacy statutes that have come out in the past few years, Is there any salvation for companies or individuals to protect against scraping via these privacy regs, whether it's the GDPR or CCPA, CPRA, or any of the other?
So yes, well, first point is that the CFA is only a partial solution to the problem because it addresses the interests of website owners, but it doesn't address the interests of the privacy of individuals whose data is scraped. Those rights really come from privacy laws. The GDPR, I think, would ban a lot of this scraping because it applies to people's personal data. Whether it's publicly available or not doesn't really matter. What matters is if you, as a data processor or data controller, have a lawful basis under the GDPR for processing it. And generally you wouldn't, right? I mean, there's certainly no consent, which is often the basis for processing personal data. There might be other, exceptions. In the US, there'd be a harder time. We don't have a comprehensive privacy law. The FTC, regulates privacy, but that's based on privacy policies that don't really apply in the scraping context. Laws like the California privacy law or even the proposed federal privacy law typically don't apply to publicly available data. So I think that Congress and the state legislatures and regulators in the US should be looking at the scraping issue and just remembering themselves that they can't just throw up their hands and say, publicly available equals no privacy issues. There can be privacy problems with the misuse of personal data, even if it has been in the past part of a public profile, for example, on a dating website.
So it sounds like there's a lot of work to be done on the legislative side to either amend the CFAA or to enhance privacy protections for individuals. Is there any other things that you think that companies or individuals should be thinking about when we talk about scraping and your research in this area?
Yeah, sure. I mean, I think that there's a lot of important questions. As I mentioned at the beginning of this webinar, scraping isn't all bad. There are beneficial uses of scraping, important ones for research and other kinds of uses, even for competition to make sure that markets are transparent. It's a complex issue and we're not going to have a single answer. But I think that, if we work together across the sort of legal technical divide, we're going to come up with better answers. I think the biggest issue is just recognizing the fact that there is real potential for harm here and that we need to do something about it. And I think it's going to require a combination of legal and policy tools and technical tools to do so.
Well, Professor Edgar, thank you so much for reviewing your paper with us and talking to the audience today about these important issues. Again, the Mitigating Unauthorized Scraping Alliance, or MUSA, the web address is antiscrapingalliance.org. Please visit us and follow our other seminars and events as we progress through the year and through these various challenges for our companies and the scraping issues around scraping. Thank you so much.